Welcome to the Employers Legal Lounge with your host, Michael Sullivan Associates Managing Partner Eric DeWong. Each month, we dive deep into a specific topic to provide you with valuable insights and guidance for navigating the complex world of California employment regulations. This podcast is provided for informational purposes and does not constitute legal advice. Only your attorney, with complete knowledge of the facts and circumstances of your situation, can determine how the relevant laws apply. Now, on to the episode.
Welcome, everybody, to Employers Legal Lounge. My name is Eric DeWong, Managing Partner at Michael Sullivan Associates Employment Law Department, and your host today. Employers Legal Lounge is a space for employers, HR specialists, risk specialists, insurance carriers, brokers, anybody interested in the crazy employment law minefield we all call California, to find out about the latest employment law updates, tips and tricks for compliance, avoiding litigation, and areas of education that you can go to update yourselves and keep ahead of the curve in this wild west of California's employment laws. So, as most of you know who have joined us before, we always have a special guest, a leader in the industry. Today, you not only get one, you get two industry leaders today. So before I introduce them, just a few notes. If you have questions, if you have ideas for podcasts upcoming, if you want to be a guest, feel free to use our Slido link for any of your questions. Reach out to me directly by email, or you can find me on LinkedIn, Instagram. You can slide into my DMs, as they say, at least as the kids say. I don't really say that. So feel free to reach out to me, and we're happy to hear your questions, answer them if we can, and consider your ideas. So without further ado, we are going to start introducing our special guests. My first guest is Christine Rodman, who has been a guest on our podcast before. Welcome back, Christine Rodman. We are so happy to have you. Chris is the CEO of Lynx. She is also the state director for SHRM. And welcome back, my friend.
Thank you for having me.
Of course.
I'm here.
And we have our friend here today as well, Tara Fournier, also known as my co-pilot, who has also many titles as well. She is the Chief People Officer at Enthusiast Gaming. She is also the president at PIRA, Professionals in Human Resources Association, my co-pilot when we do presentations for PIRA. And she has now been named the State Deputy Director at SHRM. Did I get that title right?
That's enough. Deputy State Director. Yep.
I knew I switched something around there. Deputy State Director at SHRM. So welcome, both of you. So good to see people not only that I respect in this industry, but also who I consider my friends. So thank you for being here.
For having us. I'm excited. Yeah.
And me too. And I'm so glad to have you. As you know, we have, since we are in the legal lounge, we also bring our favorite beverage, tea, coffee, water, whatever you like to sip on. If you need something a little bit stronger because we're talking about employment laws, that is also welcome. So I have my beverage, my friends. Opening cheers as we get started. Cheers to you.
Yes. Cheers.
And cheers to all of you.
Cheers to everyone.
In watching. We appreciate you joining us. Okay. So as we get started, and I'm going to leave it open for questions as we go, I like to talk initially about some legal updates in employment laws. As you know, I track these quite frequently. One of the big ones that we have been tracking is the Estrada case, which is related to PAGA. Oh, okay, that's right. For those of you who don't know, Tara, my friend, I think on one of our first episodes, introduced the PAGA drinking game. Every time we hear it, and I just said it again, we take a sip. So for some, maybe non-alcoholic beverages is best, because I think I'm probably going to be saying this a lot. So we don't drink too much. I will say Private Attorney General Act as we go forward. Estrada is a Private Attorney General Act case. Really important for employers to have watched, but as I had mentioned in prior podcasts, I didn't want everybody to get excited about it. because remember, we are in California. And when an issue is before the California Supreme Court, the chances of it landing in the employer's favor are probably really low, as is what happened here, of course. Estrada, for those who don't remember, was a case that went up to the California Supreme Court on a really important issue where defendant employers could strike a full PAGA action on an issue of what we call manageability. Manageability is kind of like a class action type of term that says essentially, hey, if these issues are too complicated, if identifying all these aggrieved employees, these employees with wage and hour disputes, would be too hard for a single case and a single judge to manage, the PAGA case can be stricken and it goes to an individual case. That was a really important issue because, as we know, PAGA is rampant through California. And one of the most common, we stick to the rules, Tara, for your game. So it is rampant in California. And what the court ultimately said is, under this Private Attorney General Act, which gives the employee who is bringing the suit the power of the state to represent these other employees, the judge doesn't have the ability to strike a PAGA action in the way they could a class action. So I know I'm suspending for the moment for those who continue to drink, unless you want to, the rule just for a little bit. So with this, what it means is, although we used manageability quite a bit in our defense of PAGA actions, we now know by the California Supreme Court that a judge can't use that issue to strike a case. That does not mean that we still don't utilize it in our defenses. It can be a very important issue, a part of that defense. But if you are in the middle of a Private Attorney General Act suit, or if it's something that comes up, understand that that is no longer an option for us in the defense world. So what I like to tether that to is some ideas of how to stay away from these Private Attorney General Act cases, because they are huge. They hit all sorts of sizes of employers. There's no limit in number like there is in class actions. In class actions, you have something called numerosity. Usually it has to be about 15 employees or more that are at issue. The Private Attorney General Act does not have that requirement. It can be as little as, 3 or 4 or 5 employees. So how do we avoid some of these things? Some of the issues that I have seen that employers kind of step in, but innocently so, because they're easy to miss, are the off-the-clock issues. Now, of course, we have in our handbooks, no off-the-clock work is permitted, record all of your time, those types of things. The issue that's coming up is the time it takes for an employee to get to that place to clock in to their time. And the bar of when hours worked starts keeps moving forward. Or actually, I should say, keeps moving back. When does hours worked start? The general law is when you suffer or permit an employee to work. The courts have been defining as anything that you are doing for the employer. That has been considered to be booting up your computer, for example. So when you get in to boot up your computer to clock into that system, it could be considered as hours worked. Is that being captured in your time? Those 2 minutes or 3 minutes or whatever that might be. Make sure that your policies cover that. Make sure that people, when they are clocking in, are actually clocking in all of the time they are working. If they're standing in line to punch a clock, that time they're standing in line, because this is not where they would normally be, were they not waiting to work, could be hours worked. Those little snippets of time make the difference of a no case to a 6-figure case really quickly. So it's really important to do these, what we call compliance audits, make sure these are compliant, make sure all time is being captured, because the courts are really going on the system of, as soon as they enter that parking lot, they could potentially be doing hours worked. And by that, I mean, there's been cases where people are punching in a code to get into a gate, to get to the parking lot. That punching of the code, arguably, even though there's not a definitive case out there yet, but this is what I'm hearing in mediations, could be arguably suffered or permitted to work. That punching in that code at the door to get in could be suffered or permitted to work. So capturing these, and this is arguably being very conservative about this, because there's not a Supreme Court case that has definitively done this. These are appellate court cases that are a little bit divided. As we know, if it goes to this California Supreme Court, where is this going to fall, right? We already learned it's going to be on the employee side. Good, Chris.
So Eric, so tell me this. So what happens for rounding purposes? So that 10 seconds that we're taking to punch in a code, or we're waiting in line to punch in, couldn't that be addressed by the rounding?
So rounding is a really important issue. I'm glad you brought it up. The cases have shown in the last year that employers should never be rounding anymore. Rounding is arguably non-compliant of where the cases are. If you are rounding in your time punches, you should change it. And I told this to many of my clients 2 years ago, because I thought that's where the law was going. This year, the law is exactly there. The courts have said we're in this place with technology where there should be no rounding. We can get actual time. There's apps. There's all these electronic resources. Employers, there's no reason to round. We also know definitively by the California Supreme Court, there is absolutely no rounding when it comes to meal breaks. But for the time clocks we're talking about, is many employers in the past have rounded time in the front or back, as long as it was neutral and didn't benefit the employer. Now, when I have litigated these cases, when I've mediated these cases, we have to go through a massive amount of work to balance out all this rounding time to make sure it doesn't end up on one side or the other. It's a massive time investment, a massive expense for your attorneys to say, well, where did this land? Is it slightly for the employer? Are we going to be in trouble, or is it more for the employee? That is kind of by the wayside at this point, because the courts have said, don't round. No more rounding. So if you get your employment law attorneys in there, your HR specialists, revamp that, especially. If you have people coming in and it takes time for them to log in or whatever that is to clock in for the time to be captured, make sure you're finding a way to capture that time. What most are doing now are the apps on phones. On an app on phone, it's easy for the employee to hit that button and I'm working, right? There's very little downtime between the app of punching in, I'm working, and punching out. Problem is computers, because that can take a while depending on how many layers you have of security to go through on yours. We have a lot. So really important to make sure all of that time is captured. If you are using apps, what's the important thing to make sure employees also get? Cell phone reimbursements. Cell phone reimbursements, because if they're using their cell phone for any purpose that benefits the employer, you have to be doing cell phone reimbursements. I recommend doing anyway. Yes.
I'm going to jump in because you know me, and all of you that have listened to me before, I'm the practical one, right? So I hear it, I understand what's being asked of us, but coming from the chief people officer's seat, that is really, really difficult, right? So I hear you, get the cell phone reimbursement and things like that. But earlier in my HR career, we were in like a factory and manufacturing environment. So people maybe don't even have cell phones. And then later on, I worked at other places where we had an iPad that sat at the front desk and you did it that way, or some sort of biometrics, which is all well and fine. But the question I think for me is, how are you actually capturing? I mean, is the time that it takes you to open your app and push the button also considered compensable time? And then how do you sort through that? What if you have to change into a uniform? All those things? Like, do you clock in, go change? I mean, just practically speaking, how are we supposed to operationalize this so that we keep ourselves safe? Because it's going to be near impossible to get it down to the second,
right. Yeah, where's the line?
What is the line? That is a fantastic question. And I have a fantastic answer for you. I don't know, because it hasn't been established by the California Supreme Court, and the line keeps being pushed. So to address your question first, Tara, that jumped out at me, what do we do if people are what we're calling donning and doffing, getting ready, getting a uniform on? That is 100% compensable time. They must clock in before they start getting dressed. If they don't, we know that that is compensable time by the California Supreme Court. So, but where is that line? Because administratively, this is really tough. And believe me, I have a lot of construction clients. I have a lot of industry. It's really hard to make happen in reality, as you suggest. And the answer is, there might be those few seconds like opening an app. It's the best we have now. And if I can show at a mediation, this is the best we have. This is the best way to capture everybody's time. And this is, less than, a minute. Now, arguably in California, there's no more de minimis law, which we have in federal law. De minimis means it's so small, it doesn't matter. But I think if you have captured it to that much, you've done the work. And I think you also get the benefit of the judge that's hearing your case, showing you, the employer, did all the things that you could. And if you do that, the judge in a Private Attorney General Act case gets the ability to reduce penalties. They have that power. And the more you show, the more ammunition you give me or your employment law trial attorney to do this, we can get those numbers down. So apps, if you can do it, and that's true, how long is it going to take you to open your phone? Probably less than 30 seconds, for most things, right? But, still.
Unless you're my grandpa.
What's exactly? I don't look at me when you say that. So those are, some issues, but I think that's the best you do. My construction clients, that is what they're doing. They're using the apps, and they're also using geofencing on these apps. So they know they're actually at work doing those things. They're not, trying to get build-in time while they're in their garage at home, right? We're still not at the place where just because somebody drives from home to work, that is still considered commuting time and non-compensable. Question.
You just said something really important, right? So that makes sense when you're arriving at work and geofencing. What about the people that are remote and that work from home? How do you capture that? Because who's to say, did they turn on their computer because they're sitting at their home? Like, how do you differentiate time from home and when start time is when you're always at work?
Sure. So for hourly employees, because this is what we're really talking about, are those non-hourly employees that are working remote, which most industries are doing. We have a very clear handbook that says this is when your time starts, this is when your time ends. When you are getting ready to work, you clock in on your app before you even get on your computer, immediately before as you are logging in. So your app is your first stop. And that is when when you go on your meal break, you clock out. You must clock out as a requirement of employment. And then you clock in. You must have no less than 30 minutes, those types of things. Having those demonstrated in the handbook and making sure that your supervisors and managers are implementing this as well, because they're going to see these time cards as they come in. They're going to see if they're compliant or not. And they can also say, hey, you didn't clock in or clock out. Or, hey, you logged in on the app at 7 a.m., but you didn't get into your computer until 8:30. What's going on? So if they're trying to capture that front end time, there's all sorts of ways to monitor this. The key is that the employer is consistent, monitoring these issues, disciplining when people are not doing these things is really important. The other thing, so I don't forget, that is a really great defense is the attestation. Attestations, for those who don't know what that means, is a document that the employee signs off on that says, I got all of my meal breaks, my rest breaks. I had no less than 30 minutes uninterrupted, duty-free. I have no off-the-clock work. My wage statements are correct. All of those things they sign off on under penalty of perjury on a regular basis. Those are, although not 100% a full defense, really get you close to it, because you have these employees signing off by hand that or on, as long as they're the only ones that can sign off on these, that's fine too if it's digital, that they received all of these things. They're going to have to argue, somebody forced me to sign this, or somebody was, did it for me. So those are out there, but the attestations are really, really important. I have clients that said, hey, this is going to be really hard. We implement this, they do, the employees complain about it, and then they stop it because the employees are like, this is taking too much time, I don't want to do it. Then they get hit with a class PAGA action, and they stopped doing it. Oh, I did that. Yep. Well, you know what? After what we've been talking about, we deserve it now.
Quick
Definitely.
Those
question.
not
Eric.
watching, we're drinking.
I do have a question. Can
yeah.
I?
Of course.
You mentioned to do that on a regular basis. So would it not work to have an employee on in their exit interview to also attest that they, to the best of their knowledge, that they've been paid for all of their, pay?
That helps. That helps. The problem when I actually, because I have had clients that have done that when I'm in litigation.
Mhm.
The argument there is if they've been working there for 2 years, 3 years, 4 years, 20 years, right? Of course, the most important is the last 4 years because of statute of limitations. How are they going to remember every single clock in, clock out, those types of things? So at the very end, it absolutely doesn't hurt, but it's not as good as a regular attestation. Most of the apps, especially the time card apps, are now using these attestations. So those are options that you can build into it. If you don't have an app that does that, have your employment lawyer or HR specialist draft one up for you that they are signing off on regularly. It may not seem like it's important now, but I guarantee you it will seem important if you get one of these LWDA notices about a PAGA action. Sorry. But seriously, the wave of these cases, which we thought might stop after a while in some of this litigation, has only increased over time because these cases are getting lost at the California Supreme Court, and it's only incentivized these plaintiffs' attorneys to file more. So I have clients that have never been sued on a wage and hour issue that are getting hit with these class and private attorney general actions. And so it's really important to shore these up. Get a compliance audit, have your HR specialist, your employment law attorney go through your time card practices, your employee handbooks, make sure that you're covered if this ever happens. If you have an existing one, still do that because there's a way to mitigate these damages if you correct these issues during the process. The length of a class or a private attorney general action can be years, 2, 3 years. You don't want to wait until the resolution of that to make changes, because the longer you are in that case, the longer the penalties, the longer those damages are piling up until you get to a mediation. So make those changes. Just because you make those changes doesn't mean you're making an admission. It means that you're mitigating and just making sure shoring up your better compliance. So sorry about that. It was meant to be a very short soapbox statement about wage and hour, but hopefully that was a good discussion for everybody.
Great information.
Is there any other questions on those before we get on to?
I just have a follow-up to
Yes,
the,
please.
so when we're talking wage and hour and we're talking, let's say, meal periods, the employer is required to afford these meal periods or these breaks.
Provide, yep.
You're providing them, you're affording them, and then you have someone signing the attestation. So does that hold true? Because I know, what was it, the Brinker case back
Yes.
in 2012
2012.
basically states that, as long as you afford them, then you don't have to go and police it. So
100%.
what's the remedy though? So is the employer then pretty safe to assume that if they've afforded them, it's in their policy, at their handbook, it's in the attestation, that they're golden, or is there still some room
There's
in the law?
great question. And unfortunately, there's a whole heck of a lot of room in the law, because what Brinker said is you don't have to police these employees. You must provide the meal break, meaning make it available, a duty-free where it's not uninterrupted. When we get these, and although we say, hey, we provide it. Well, no, my supervisor took me off at minute 29. We had a rush to get something out at minute 24. We had, all of these things, these individual issues come up. And yeah, their policy might say we provide it, but look at the time cards. The time cards are, consistently meal break violations. Now, the response to that is for everyone, hey, did you do this on your own? Some employees want to work through their meal breaks. Can they do that? Yes. The problem is they might say, I want to do it now, but when the Private Attorney General Act or class action comes up, they go, oh, well, I felt forced to do it. It changes. So when you get the attestations in real time, they're saying it was provided to them, it was given to them in conjunction with their time cards.
Mhm.
Now, in dealing with this in real time, if you get a time card that says 29 minutes, what the attestation should do is say, did you not have your full 30 minutes by your own choice? Yes or no? Was this required by your supervisor? Yes or no? If it was by their own choice, no meal period premium is owed. If it's
Nice.
something other than that, it's not provided because a supervisor got in there. Then you get to investigate it, talk to the supervisor. Did that really happen? Well, yeah, we're really okay. Then you reprimand the supervisor, right? Or the supervisor says, no, that didn't happen. I don't know what you're talking about. And you investigate it further. In those cases, if it's a question, you still pay that meal period premium, which is the 1 hour premium pay, which is considered a wage now, in that moment. And I think your question also brought up, Chris, a really important component and change in the law. It used to be that we thought these were just penalties, this 1 hour. It is now considered a wage. So we have to pay it right away. And certainly before they leave, there's a waiting time penalties fee. So if you don't get all of those paid before they leave or in real time, it can be a massive issue. So clocking this in real time, having your HR check, why did you only get 29 minutes? What are the reasons? Your attestations can typically do that. Some of these apps have the questions built in. So it'll automatically give them a premium pay if they answer the question appropriately. And you can track those. I know it's a really long response to your really short and well stated question. I hope that helped.
It did. Thank you.
Yeah, and I think everybody else is struggling with this too, because like Tara said, easier said than done. Eric, you and your employment lawyer, yeah, tell us what the law is. But yeah, we're the ones that have to make this happen and still do the 10,000 other things that we have to do. So thanks. But all I can tell you is what the trends are and the best ways of doing it. It's a moving target all of the time. Let's see. My next one, I think I can wait until, one other thing just to put on everybody's radar is the workplace violence prevention requirements that came into on January 1st. They must be in place by July 1st. So I get questions what does this mean? What do we have to do? Do we just, can you just send us a template and that'll be enough? And the short answer to that is no. This is a new generation law, nothing like it before, has all sorts of requirements that I just can't get into here. So because of that, PIRA is putting on a full 1 hour presentation for it on April 11th. I will be presenting on all of the requirements, how to be compliant. It's not, I know it's not the most fun topic to talk about because usually like something fun and entertaining, but it's really important. And it's really hard to navigate if you're just reading the statute and trying to be compliant. So we'll try and help you through that on April 11th. And if you watch either PIRA's or my Instagram and LinkedIn accounts, you'll see all the registration links and that type of thing.
Awesome.
Really important. Definitely important. If you've listened to the podcast before in the past, you've heard that I've had some of that experience firsthand, and it's, it may not seem like it will happen to you, but it may, and it's really important to make sure all your employees are ready for it. So, I know it's one of those things, and this one, Eric, I'm not like, hey, lawyer, okay, fine, but practically, just from personal experience, not only is it the law, but it's really important. So please, get all the information on it out there and get it going on, because we need to keep everybody safe.
Yeah, I agree with you. This is more than just, another thing we have to do type of thing. It is hard to be compliant with it, but of course we never expect these things to happen. We hope they never do, but be prepared. And as Tara suggested in prior podcasts and told you, it's happened to her. And they're, having a plan in place makes all the difference in the world.
So will it be virtual, or is it just in person for PIRA's thing on the
it's going to be virtual.
Virtual.
Yep. Virtual 1 hour training for everybody. And I have one other, but I think I can wait until we talk about our upcoming education series to talk about the next issue. And so I wanted a little bit of time to let everybody know where we at on time real quick. I just want to make sure. Oh, yep. So we have a few things coming up. One is that Tara and I will be presenting at the California HR conference in May 20th through 22nd in Anaheim this year. My co-pilot and I will be presenting again on a topic that is really on everybody's lips these days. Questions I get daily, which is artificial intelligence and human intelligence, that crossover. There's I'll tell you, I don't know how you felt about it, Chris and Tara, but there's a point where I'm like, I have so many other things I have to watch and take care of. This thing, I can wait, right? And that's how I felt about it about a year ago. This is not a wait and see issue. This is our reality now. Laws are coming out, laws for employers, for lawyers, EEOC, the Civil Rights Department, all of them are putting out really strict guidance on AI, and employers and HR, we have to know the lingo, even though I know this feels like an extra thing. Even if I'm not a tech person at all. I barely know how to use my phone, but I have realized that I have to become an expert in this in order for us to be ahead of the curve for these lawsuits, because these will be the next generation lawsuit in AI. So Tara and I deciding if you need to go, you can go on automatic pilot or not on our plane ride. I'll cut to the chase and say, nope, you can't, but we'll tell you why, and we'll tell you how to avoid, some of these things in ours. We'll also
I didn't even say Paga, so be careful.
Did I say?
Did it?
Yeah.
I said we might say Paga, so be careful.
You said it twice. You just wanted to take a drink. I like it.
It was thirsty.
So we also have on May 21st a happy hour that Michael Sullivan Associates is hosting at the conference. If you can join us, it is going to be at 6 p.m. at the Rise at the Westin in Anaheim. We do throw a pretty good party, so come and join us and it'll be fun. But more important for now is something more pressing and upcoming, which is our SHRM conference that comes up next month, April 17th through 19th in Sacramento. This is a live conference. We will all be there together, the three of us and all of you who want to join us. Some of the really exciting things that are going to be taught and trained are harassment training. How do we do this in the workplace? There'll also be some AI training there. I will be doing a presentation on return to work issues as well. After we talk a little bit more about this conference, I'm going to get into a couple of those things to highlight to make sure we're being compliant. And it's a 3-day event, lots of fun things to do. And the firm will also be hosting a happy hour on the 18th at 5 p.m. at the Sheraton. So please join us then. If you've not noticed a theme between our legal lounge and our happy hours at these conferences, there is a trend. We do like to get together and have fun. So did you, Tara and Chris, could you tell us a little bit more about the SHRM conference? There's another component to it I have nothing to do with directly, but I'm going to join because it sounds so exciting, which is the On the Hill visits.
Yeah, so, our conference is a very unique conference in that it's not just focused on HR. It focuses on HR and advocacy. And so it's an opportunity for participants. They have to sign up. So you can't just show up. You have to actually sign up ahead of time. And based on where you live or where you're registering in your zip code, you'll have the opportunity to meet with a lawmaker or a staff member of a lawmaker to talk about 1 or 2 employment bills that are relevant, or basically giving us the opportunity, because HR often wakes up one morning and there's a new law and we don't know what to do with it. This is a unique opportunity where we have a voice and we're able to go and speak to it and share from an HR professional's perspective of how that's going to impact our businesses. So it's a phenomenal opportunity. I know Tara is very passionate about this. I'd love to hear also what Tara has to say about it. She's also done the conference and the ledge visits. So go ahead, Tara. Go ahead and share.
Yeah, this is one of my favorite parts of being involved in places like Pirate and SHRM, because I do feel like, like I said to Eric and you all earlier, I'm the practical person, right? So I hear the law, I get it, but how the heck do you put that into place? And I know that, like, for example, in Congress, so I'm going to go national and then I'll go back to state, there's 435 members of the House of Representatives. And I believe currently there are 2 that have HR backgrounds. So
Wow.
433 people making the laws about what an employer does and how we operate have never sat in the seat of HR or understand what it means to operationalize whatever it is that they're doing. And I would say, I don't know the fact for sure, but I would say in the state of California and all the state legislatures, it would be somewhat similar. You may have some business owners, you may have some folks that have some business acumen, but true HR professionals, not so many. So what's really great, and what I've found going to these, it's a little bit intimidating at first because you're like, oh my gosh, I'm talking to my state senator, I'm talking to my assembly member, I'm talking to my legislator. They're human too, and they want to understand how it impacts the people that live in there and work in their area. And they don't know. And so they're looking for us. They look to us, and we've become respected, at least in SHRM. And Chris could speak to this. We've been asked to go to the state capitol and testify and give our experience in congressional hearings and in state committee hearings, because they really want to hear from us. And it's a cool thing to not just be part of HR, but to like help the future. And there's all sorts of different things we've been going up to talk about in the past. There was one about veterans and having a preference to hire veterans and helping in that area. We've done things about tuition reimbursement. There's all sorts of different issues that you hear out there. And we have the backing and support of our national organization, SHRM, to help us, put together what we're going to come talk about. It's super cool. And if you've never had a chance to do it, if you're shy, you can just sit and so there's always somebody that wants to talk, but just come and experience it. It's so cool.
That is, I can't tell you, and I'm sorry I didn't really know more about this before, because this is really exciting. One of the number one things I hear from my clients, which are employers, HR specialists, that type of thing, is, Eric, how is a business supposed to run with these laws? How are we supposed to make a profit? How are we supposed to do what we do and still stay compliant with all of these changing laws and rigors of California law? And my response to them is, the legislature, the people who are lobbying, the people who have a face out there, the plaintiffs bar is a big lobbyer in these. They absolutely show up in person and they lobby for these laws, like the Private Attorney General Act that came out in 2004. That's why they're on the books. So if this is an opportunity to speak with these people who pass these laws, to give you, this is, for those listening who have this question of how are we supposed to operate, this is your time, not just with the ballot, but also to be in front of these people to say, this is how this affected my business. This is how, we try to do the right thing. And this is usually the story. Employers trying to do the right thing, have their own employment lawyer, have their own HR specialists that are around the clock trying to do it, but they still can't keep up with it as much as they try. And I don't think that's the intent for these laws. They're meant to protect employees, but they are misused by the plaintiffs' attorneys out there. They're misused by people with less justifiable agendas. Let's just put it that way. So I will be there with you for sure. And if I have an option to speak, I would love to. And if you're an employer, HR specialist, people have been worried about this, take the opportunity. That's kind of really cool that you guys set this up as an opportunity for us. So
well, it's really important that we share our voice, because again, we're the ones that are the boots on the ground that have to implement some of these laws, and having that voice, at least you tried to do something and make an impact.
Yeah, and it does. The more voices, the more it does make a change. And I think, people they like to say this is a terrible thing, but take the opportunities when we get them to actually see if we can make a change. So thank you for letting us know about that. Thank you for educating me a little bit more about that, because I'd seen it on the agenda, but I didn't really fully understand what we got to do as part of it. So thank you for that. I think that we have just a couple of minutes. So I just wanted to mention a couple of things that I'll be talking about at SHRM just as a highlight, and it also goes into one of the updates that I'm seeing. I'll be talking about return to work issues. Those have been to my presentation before, and ones that I've done both with Tara and Chris on the subject. It's a really important issue that never stops, because there's no bright lines in these return to work laws. The crossover with workers' comp, employment law, how do we accommodate, what leaves are out there? But one of the things that I'm seeing as a trend in the law recently is not only a heightened number of lawsuits filed under the Fair Employment and Housing Act, which is under disability discrimination, these return to work, leave of absence, SFRA, FMLA, but also, for those who've been at the podcast before, the RAINS issue. And the RAINS case has extended the definition of employer beyond just an employer. The nutshell is almost anybody who is doing any activity that could be considered for the employer, giving input about accommodations, giving input about whether you can terminate somebody or not, outside somebody's direct legal representative, could be considered an employer under the Fair Employment and Housing Act. I'm seeing more and more lawsuits tethering insurance carriers, brokers, third-party administrators, HR specialists, that are because plaintiffs' attorneys are aware of this, and they're trying to get at an additional pocket to pick for these. As those of you, if I remember, I mentioned this back. I've been preaching about it, and I have cases I'm defending on this as well. So this is a reality. My notes on this, for those who can't make the conference, just for a couple of notes, is if you are an employer, understand that it is always your direct responsibility for these accommodations, the interactive process. The laws are tethered to you directly. Don't assume your third-party administrator, your outside HR specialist, your outside, broker or carrier is covering you, especially when there's a workers' comp claim. The idea typically is, well, I have a workers' comp attorney that's handling the workers' comp claim, so I told them I couldn't accommodate, so they're going to translate it, or the third-party administrator is going to translate it to the employee. Your job is not done by them and can't be assumed by them. You will still be responsible, even if they don't get it right. So make sure you're taking that under your wing for your responsibilities, your interactive process, your documentation for all of those, and not assume it's the third-party administrators or the outside broker. For you that are a third-party administrator, broker, HR specialist, remember also that when you are advising or going outside your normal purview, you could be under this umbrella of employer as well. So saying things like, oh, you don't have to accommodate them, or that's not reasonable, you go ahead and terminate. Once you start giving that direction, then without saying, hey, let's talk to your employment law attorney, but give those caveats. Once you start going outside of your purview, you are now assuming potentially an employer class under RAINS. So all of these things, we have to stay in our lanes. It's really important to do that. And if we are a third party and we do this on a regular basis, make sure you have an appropriate contract so everybody understands what their responsibilities are and where the liability falls if any of these things happen. That's my my second soapbox. I'll get off that because both Chris and Tara, you both heard me preaching about this, and I just keep seeing more and more of these cases, and it frustrates me for the people that are being sued under this, because I think this is the wrong way for this law to go. But again, this was a California Supreme Court decision, so we have to deal with it as we are. Maybe something else also to bring up on the Hill on 418. So because if anybody's going to talk about it, I'm happy to bring that one up. So that is all of the time we have in our lounge. I hope this was informative for everybody listening or watching. I hope you had as much fun as I did, because I love talking with you, Tara and Chris. You guys are such a joy, and I had such a wonderful time with you both. Thank you. Thank you. And our final cheers to both you, Tara, Chris, and to all of our listeners and watchers. Thank you so much, and we will see you next time.
See you next time. Cheers.
Thanks for listening to the Employers Legal Lounge podcast, presented by Michael Sullivan and Associates. Remember to subscribe on your favorite streaming platform so you never miss an episode. We release new content every month, ensuring you stay informed about the latest developments in California employment law. If you have any questions, topic suggestions, or would like to be a guest on our show, don't hesitate to reach out to us at msa.news/podcast. We'll see you next month with another episode of Employers Legal Lounge.